More than half of those infected with COVID-19 could suffer from post-COVID syndrome more than 3 months after testing positive. That's according to a review by the Public Health Agency of Canada. For many long haulers, it's affecting their ability to work. For more on this, we're joined by employment lawyer Alex Lucifero. Alex, so what can someone do if they had COVID-19 and are still suffering those long COVID symptoms that just make it really tough to get into work?
Sure. Well, the first thing you should be doing, Patricia, if you're one of those individuals that are still struggling with those post-COVID symptoms, is keep in very close touch with your primary care physician. So be it your family doctor, any specialist that you're dealing with. You need to show, either to disability insurance companies or otherwise, you need to show that you are seeking treatment for these issues. And you will ultimately want your doctor's opinion on whether you are able to work or not. And if certainly your doctor is ordering you to take some time off, take a medical leave of absence because of these symptoms, then you should be approved for disability insurance.
You want to have that in your medical records, obviously, going forward, right?
Correct, absolutely.
Okay, so how are insurance companies reacting to disability claims related to COVID?
Yeah, that's certainly a separate question, Patricia, and regrettably, not all that well. I mean, obviously, this is a very novel issue, but I hate to say it, insurance companies are certainly in the habit of denying insurance claims that are not particularly clear. So, of course, we can all imagine situations where it's very obvious that an employee is unable to work, medically speaking. But there are certain situations, these COVID long hauler symptoms being one of them. Mental health issues is another such example, Patricia, where insurance companies are more likely to deny insurance coverage simply because these symptoms and this inability to work is not as obvious as in the case where an employee has a very, very clear and obvious physical limitation. So, hopefully insurance companies are coming to terms with these situations and recognizing that. And it's been our experience, Patricia, as a law firm, that there are employees out there that are really, really struggling with these long hauler symptoms, and they are owed disability insurance like any other employee who's medically unable to work.
Still pretty new territory, I guess, for everyone. But what do employers need to consider if an employee is experiencing some of those long hauler symptoms?
Sure. From the employment point of view, a couple of considerations here, and specifically from an employer's point of view, the first point would be, well, if these employees are unable to work, and if they can substantiate that they're medically unable to work. So if they provide a doctor's note, doesn't have to have any real level of detail there, but a doctor's note confirming that an employee is medically disabled, the employer has to allow that employee that time off. They cannot punish an employee or terminate an employee because they've taken a medical leave of absence. The second point I would make is employers actually have an obligation, an actual proactive obligation to accommodate these employees. So in situations where an employee can still work, but in only a limited capacity, because of these COVID long haul symptoms, well, the employer has to accommodate. They have to play ball. They can't simply, again, punish an employee or send that employee home because perhaps they can only do part-time work or they can't do particular aspects of their jobs. Employers have to accommodate. It's a very, very high bar for employers. They have to engage.
All right. Interesting topic. Employment lawyer Alex Lucifero, thank you so much for joining us today.